All right, welcome to my YouTube channel. In case you are meeting me for the first time, this is Prof TV. Yes, so today we will be looking at techniques of social control through law. And for those that have not watched from the beginning of legal method, you are doing yourself more harm than good if you continue with this particular video without going to watch the other ones before this one. So today we'll be looking at techniques of social control through law. But before we go into the techniques, because the techniques are already on the board, we have the penal techniques, we have the grievance remedial technique, we have the private arranging technique, constitutive technique, administrative regulatory technique, and fiscal technique. Then we have the conferral or social benefit technique. Now, before we even look at all these techniques, yes, I forgot to mention the penal technique and the grievance remedial technique all have alternatives in case it doesn't work, or what you can resort to instead of using penal and grievance remedial. So, but before we go into this, I want you to understand this thing very well. Not necessarily because okay, you want to go and write exam, but you have to know it, you have to understand it. Now, we will have to first explain the meaning of social control and whether there are other techniques of social control that is not through law. Because the one that we are interested in, because you're a law student, you are a prospective lawyer. The one that you're interested in is how to control the society, or how the law controls the society, and the techniques at which it uses to control that society. So what is social control? Long and short of it is the control of social behavior or human behavior as it relates others. So what do I mean? If my behavior would affect you, the other person, when you say social, it means not just individualistic. We are talking about the society. So if my behavior will affect the other person, then we are talking about social behavior. Now, because we know that we are human beings, and human beings, human being, of course, we are higher animals. And if you look at how animals live, you would know that even Thomas Hobbes have stated it, that without law, man's life will be nasty, brutish, and short. Anarchy would be everywhere. It would be survival of the fittest. Because there is no law guiding my movement. There is no law curtailing my excesses. So, I would do anything I want to do. It will not be the rule of might. The only people that would now be alive are the people that are strong physically. But now we have the law. We have the law. So, the people that are even surviving our society as it is now are not necessarily people that are physically strong, but people that know their rights, people that are knowledgeable about their rights. That is why you will see that somebody will be arrested, and the person would know that, okay, you are not supposed to spend more than 24 hours in the police custody. If you do that, especially when a court is within 40 kilometers radius, then you can now go to court. But if you do not know it, you will probably rot in that custody. So, that is it. If there was no law, man's life would be anarchical. So law came, and it is succeeding in curtailing the movement or the excesses of man. Now, one of the functions of law is to bring social order. And how does the law do this? The law does this by curtailing our social behavior. And I explain social behavior to be behaviors that would most likely affect the other person. So if I steal, for example, I have affected the other person. And so it is important for law to control that my urge to steal. If there was no law, I could steal and nothing will happen. But since there is law now, banning or criminalizing stealing, then I would have to think twice before I go to steal. Because I know that if I steal, the law will catch up with me. So that is social control. Now, there are techniques of social control, not necessarily through law. Now, I've been talking about how law, I've been controlling the social behavior just when I used the example of stealing. But when you look at other techniques, you have other techniques like in Igbo land, if somebody does something that is not supposed to be, I think most of the times they do this Osu system. They will now banish you from the village. Yes, that one is an informal kind of technique. So in our society, in our community, in our villages, there are some ways the community controls social behavior. So if you go to your village, most of the times when you as a wife tries to talk back at your husband, maybe the Omoada, that is in Igbo land or something, the Omoada or the Nemudi, that's the women around there, would now come to your house and do all manner of disgusting things because you are a disgrace to them. So they would look for how they punish, even though it is not necessarily the law, but this is their own technique of controlling your social behavior. Do not disrespect your husband. This is what we would do if you disrespect your husband. Maybe we will parade you around the whole village and singing for you. You are disrespecting your husband, though. This woman is disrespecting his husband. Just to bring disgrace to you. So that is a technique of social control on its own. But today we are looking at the technique of social control through law. So our watchword is the law. What we are looking at is the law. We are not looking at the primitive society. We are not looking at how our villages, do their own social control. We are looking at how does the law control our social behavior. Now, these methods, we have the penal technique. Now, from the words, from the names, it is easy to understand. From the names, they are easy to understand. When you say penal technique, what comes to your mind? Penalty. Not football. Please, my football lovers. Penalty, in the real sense of it, is kind of like punishment. What kind of? It is the punishment you get when you say, what is the penalty of this thing you are doing? This thing that you're doing, what is there any penalty? It means penal technique. And when I'm talking about that, I am talking about crime, criminal law. Penal technique, this technique criminalizes, is a technique used in criminalizing a particular action. When it is criminalized, it is also a technique used in noting the punishment of that action. Because of course, your section 36 subsection 12. You cannot be convicted if the law is not written and the punishment prescribed. So that is penal technique. It shows how to criminalize a particular action. It shows what happens when somebody goes against that particular law. It shows the penalty, the punishment that is accompanying that law, and it shows the procedure through which you are to pronounce that person guilty. So somebody has done something. Yeah? Somebody has, let's say you are not expected to kill any other person. So and the punishment is death. So somebody kills another. What happens? You have been arrested. Now this is not the procedure. When you kill, what do you do? What will they do? They will arrest you. And who will arrest you? The state. That is why any case you see, Emeka versus the state, Obi versus the state, it is a criminal matter. So they will arrest you. What will they do when they arrest you? They will have to investigate that offense. To investigate, when they investigate to get necessary evidence, they will now arraign you. When I mean arraign you, it means bringing you to court in order for them to read your charge for you. On this day, you did this, guilty or not guilty. How do you plead? You now say not guilty. Now, when you say not guilty, the prosecution will be expected to prove his case beyond reasonable doubt. Now, this is not evidence class, so there is no need to go into Section 131, Section 130, or Section 132 of the Evidence Act to talk about the meaning of beyond reasonable doubt. When you get up in your level, you're in year one now. I assume that if you are watching me, you are in year one or you're about to enter year one in law. So just understand this one that I'm saying. So the prosecution is expected, and who are the prosecution? The prosecution is the state. They are expected to prove their case beyond reasonable doubt in order for you to be convicted. Because of course you know that every person is presumed innocent until proven guilty by a court of law. And that is what the prosecution is trying to do, to prove that you are actually guilty, for the court to pronounce that you are guilty. So after the prosecution opens and closes his case, the defense will now open and close his own case. The defense is opening his case to disprove whatever it is that was proven by the prosecution. And how do they do it? You are supposed to prove beyond reasonable doubt, I mean the prosecution. If the defense succeeds in putting a doubt in the mind of the judge, then he will be exculpated. Exculpated means he will be discharged and acquitted. He will be found not guilty. So, but if he is found guilty, then he will be pronounced guilty and he will now be sentenced to whatever punishment the law has prescribed. So that is penal technique. How does it now control our social behavior? Now, if you know that this particular offense or this particular action is an offense under the law, and you know the punishment that is accompanying it, will you want to go and do that action? Now, if you do not do those actions, it means that the society would be peaceful. The society would be free from crimes and offenses. And when the society is free from crimes and offenses, then you will now see that there is orderliness, there is peace, there is tranquility. So it has now succeeded in controlling our social behavior. So that is penal technique. However, even though we have the penal technique, it is still not enough. Because when you even look around, we have these laws, very beautiful laws. We have laws criminalizing so many actions. But those actions that are being criminalized are still being perpetuated by criminals. So, penal technique has not really done much. Even though it has done much, but there is still remaining. And so, why we have penal technique, we also have the alternatives. In case it is problematic or in case it doesn't work, the penal technique, then the alternatives to penal technique can be utilized. And number one alternative is the non-intervention. Non-intervention. You don't do anything. There are some offenses that you do not really even need to criminalize them because it doesn't really affect social behavior. It doesn't really affect the society. Let us take, for example, there are people that believe, even though we know that rape is an offense, so many societies have criminalized rape, but so many societies are still contemplating whether or not to criminalize homosexuality and lesbianism. Non-intervention. So if your country has not criminalized homosexuality and lesbianism, then if you engage in homosexualism or lesbianism, then nothing will happen. Now, this is where you now have that dichotomy between law and morality. There are some actions that morally shouldn't even be in existence, but legally it is not criminalized. So what do? Even though it affects the behavior of other people, you non-intervention. You don't do anything because the law has not permitted you to do anything. So that is alternative. Now, compounding, even though yes, crimes may occur, but when we talk about compounding, we are talking about reaching an agreement. You have destroyed my car. This is what you are expected to pay me, at least for compensation, so that I will not chase or I will not prosecute this matter further. Now, if you reach that agreement, then there is no need to go to court to prove that he actually did it. So most times, you know how all these Dangote trucks will go and hit people. Because Dangote has money, he might just say, my truck has hit this particular person. Just like what happened in Fena's case. Fena's sister hits the lady and paid compensation. And the reason he would pay compensation is probably so that they would not chase that matter. Because if they chase it, his reputation is at stake, the company's reputation is at stake, and all that. So compounding is when you reach some agreement in order for the complainant, that's the nominal complainant, the person, the victim, not to maybe call police and prosecute the whole matter. So that is compounding. You reach an agreement. You killed my son. I would have said let us call police, but this is what you will do. In order for me not to call police for you, or in order for me not to prosecute this matter further. Agreement between them for some kind of compensation and all that. Now, self-help and reciprocity. We all know about jungle justice. Yes, even though that is not a good style of justice, but it is an alternative to penal technique because it controls the behavior of people in these cities that you, of course, you know that yes, if you steal, they will burn you alive. So it succeeds most times in controlling that behavior. In contrast to when probably there is nothing like that in those cities. But then you know it is bad because most of the times people have been burnt alive that were innocent. And so because they were not given fair hearing, they were just burnt alive, then you see that you have actually brought injustice and not really justice. So that is self-help and reciprocity. That is an eye for an eye, a tooth for a tooth. The person that something happened to, they can give the person opportunity to do the same thing to you. Ah, you killed my son, okay. Oh, yeah, go and kill his own son. Warning and caution. Now, this one this one can be punishment prescribed by the law. So there are some offenses, especially when we talk about juvenile offenses, that the punishment is warning. But apart from that, because if you even talk about it as a punishment, it means you're applying the penal technique, which you people have finished proving the case, and the punishment is just warning. But as an alternative, it's possible that you would not want to go ahead with the court. You just warn the person. See, don't do this again. If you do it again, we will arrest you and we will charge you to court. So that is that about penal technique and its alternatives. So remember I said that penal technique is related to criminal law. Criminal law. If you don't know what criminal law is, and if you cannot differentiate it with civil law, because grievance remedial technique deals with civil law. Now, if you do not know what criminal law and civil law is, you're not supposed to be here. You're supposed to be watching my previous video in this playlist. So, grievance remedial technique, civil law, even from the name, grievance. You have something that somebody has done to you so bad. Remedial, the person is supposed to give you compensation, remedy, in order for that thing, in order for you to be compensated. So that is just it. When you are in, maybe you enter into a contract with somebody and the person breaches, you are suffering injury, you have suffered some kind of grief. Yeah. So in order to put you back in the position you were, restitution to put you back in the position you were before you entered into that contract, the person would have to pay you damages or do some specific performance in order for you to be compensated. But now remember that this particular thing is something that the courts will have to state. That means if you breach a contract that we entered into together, I will have to go to court, and court will now be the one to make the order that you pay me damages. Damages means monetary compensation. Pay me damages, or do some particular thing that I want to be done that you did not do. So if the court states it, that means that is grievance remedial technique. That is the technique pertaining to civil law and not criminal law. So we have to note that when we are talking about grievance remedial technique, we are looking at the court system. Yes, civil law, wherein you have breached. Remember what civil law is. Like I said, if you are here and you are watching this particular video and you have not watched the classifications of law, you are doing yourself, because these things build upon each other. You cannot, if you are counting 1, 2, 3, you cannot go and count 5 when you have not counted 3 and 4. You understand? So your understanding of civil and criminal law as a classification of law would enable you to understand penal and grievance remedial technique. So when you are talking about civil law, like I was stating in the classifications of law, it is regulating individual relationships, while criminal law, of course, when you talk about offenses and the state prosecuting, you are not really looking at you and the fellow citizen. You are looking at you and the state. So the state prosecutes the offenses. The state is the people that will charge you to court. But the grievance remedial technique is on civil law, and civil law deals with individual differences. If you injure me, I want a remedy. if we enter into a contract and you do not deliver your own part of the bargain, I would want to be pacified. I want a remedy. How do I get the remedy? I will sue you to court. When I sue you, then the court will give order for you to pay me damages. It will not be an order of court, of which if you don't do, it is now a contempt of court, which probably you would go to prison if you don't do it. So that is grievance remedial technique. But there are alternatives. So instead of us to go to court for this particular um, grief that I'm suffering, we can do other things. Now, the penal technique is here. Now, I know most of you be wondering, how is penal technique an alternative to grievance remedial technique? Now, penal technique is usually an alternative to grievance remedial technique when that particular action that you are complaining about, that, of course, you can sue. When that particular action can also come under the purview of criminal law. What do I mean? There are some actions that, yes, they are civil in nature, but they can also be criminalized. In fact, not that they can also be criminalized, they are criminalized. So if you go to the criminal code or the penal code, you will still see these actions there. Of course, you know an offense must, before an offense is an offense, it must have to be written down and the punishment thereof prescribed. Section 36, subsection 12 of the 1999 Constitution. So, when we are talking about penal technique, we are say, okay, alternatively, instead of just suing the person to give me compensation, maybe I don't need your compensation. Maybe I just want you to suffer for what you have done to me. I can just prosecute. I can just call the police. The police will now prosecute the matter and go through a penal technique method. That is treating the criminal aspect of that offense, of that action. That is it. That is alternative to grievance remedial technique. But of course, you can still chase the two at the same time. This is by the dilapidation or the removal of the rule in Smith against Selwyn. In the rule in Smith against Selwyn, it was stated that before a civil matter, if a particular action is civil and criminal in nature, that you must first dispense with the criminal aspect before going into the civil aspect. That is the case in Smith versus Selwyn, but it has been made away with. We no longer practice that because, according to scholars, they say it is anachronistic, it is archaic, it is antiquated. So, the two of them can be simultaneously taken in court, but of course, it is under the alternative. So, alternatively, instead of just going to court for individual remedy because you are suffering grief or injury from a breach of, not only breach of contract, like okay, example of those actions that can be civil and criminal in nature, we have assault. So you can charge somebody for assault under the criminal code. You can also sue for assault or battery. Another one is defamation. In our Nigeria now, defamation is also criminal. Yes. Then you can also sue for defamation. So there are places this penal technique can come in. That is an alternative to grievance remedial, or maybe you can take the two of them simultaneously. Another alternative is private settlement. Instead of going to court, why not, instead of going to pay lawyers, lawyers will come and be charging us too much money now. Instead of going to pay lawyers, why not let us come together and agree on a settlement? Okay, what did I do? Okay, I did not deliver 2 trips of sand. How much is it? 1 trip is 50,000. On that trip, that is 100,000. Okay, see, compromise, please. I don't have 100,000, but I have 80,000. Will you accept? If the other person say, no problem, give me, I will accept. You have settled the problem. Instead of going to court, paying lawyers, and they will come to court and speak English every time they go to court to give them appearance fee and all that, you now find out that the 80,000 that you have to even settle, you even use it and pay lawyers, and before the judgment might come and they will now say pay 500,000 damages. You get? So private settlement is an alternative to grievance remedial. So when you come together, you settle privately instead of going to court. Now we have insurance, of course, for countries that practice very good, effective insurance regimes. When, let's say, for example, I bash your car, you don't need to sue me because I bashed your car. Yes, you've suffered injury. Of course, it's grievance remedial technique. But if I have a very good insurance and you have a very good insurance, I can just give him the details of my insurance, so tell my insurance that see I've caused trouble. My insurance will now take care of the whole bill. But people, Nigerians don't like to. It's not as if insurance is not in Nigeria. There is insurance in Nigeria, but it's just that Nigerians will be looking at it as waste of money. And say, okay, insure your car, insure your house. You'll be paying small, small, paying. I see it's called premium, paying the premium monthly, yearly, or anyhow. So that when something happens, when something bad happens, they can just take care of it without even you spending a dime. So insurance is an alternative to grievance remedial technique. So that is where you have insurance and it's effective. Arbitration, instead of going to court, you can go to arbitration because arbitration is an alternative dispute resolution mechanism. So instead of going to court, which is probably more time wasting, arbitration is very good because even most of the commercial transactions that is being done now, especially all these big scale commercial transactions, most of their written agreement have clauses of arbitration. So arbitration is extremely important. I'm not going to go into deep into arbitration, but we have advantages of arbitration. The person that will sit as an arbiter over the matter is probably somebody that has expertise knowledge, somebody that has more knowledge on that aspect, and not just a judge that is just an expert in law and probably not in that angle that you are coming. Maybe that aspect, maybe it is an aspect that has to do with shipping, maybe maritime and all that. Maybe the judge himself that you are going to is not an expert in maritime law, but the person that will probably sit as the arbiter in arbitration would be somebody that is an expert in the maritime sector, and so you would have more informed decisions. And again, in arbitration, it is not a winner and win-lose situation. It is a win-win situation where after you are done with the arbitration, you will still maintain your personal relationships. Not like in court where one person must win, one person must lose. And after judgment is being delivered, you are now an enemy of the other person. So there are so many advantages of arbitration, which if it is captured in the clause of your agreement before you enter into it, maybe in the case of any breach, you will resort to arbitration before going to court. And if it is in your clause, mind you, if there is a clause of arbitration in your contract that you people signed, and there is a breach, and you just will jump immediately and go to court, the court will tell you that it is premature to come to the court. That you must first exhaust that clause of arbitration that is in your contract. In arbitration, their judgment is called arbitral award. Yes, and it's binding. It's binding actually. Yeah. So we now have the private arranging technique. So from here, they don't have alternatives. So we just look at them one after the other. So private arranging technique is where the law has given you the opportunity to agree on what maybe you people has plenty. And that's okay. In this group now, this is the law has given you the opportunity to know how you will guide your group, to know how you will go about your activities in a particular group, but within the legal framework. So what do I mean? Let me use an example, like marriage. You are not expected to marry. It is not a must. They did not say you must marry. But once you want to go into marriage, private arranging technique means that you will have to now have the opportunity to choose. You have the opportunity to choose how your marriage will go, to choose the kind of marriage you want to do. Private arranging technique. Yeah. So you have the opportunity to do what you want to do, but within a particular legal framework. Now, I'm using marriage as an example because marriage, there are three ways you can engage in marriage. One is the statutory marriage, customary marriage, and probably Islamic marriage. You are not expected to marry, that is number one. But if you now want to marry, then there is a framework. You must have to choose between these three. So if you are choosing statutory marriage, there are things in it that you must still have to follow. Because somebody that has engaged in statutory marriage will not marry another person. It is an offense if you do that. So it gives you that opportunity to choose. It gives you that opportunity to chart the course of how you want your arrangement to go. So apart from marriage, we have contracts. can enter into a contract with anybody about anything, but there is a legal framework. You cannot come and enter into a contract with somebody to go and assassinate somebody, because it is not within the legal framework or what is legally right. But there is a legal framework. That is how you will enter into that contract. But you have to choose. How are you to pay? It is your own volition. You can choose that. How do you pay? When do you pay? Will you resort to arbitration? Will you go to court if there is a breach? So that is private arranging technique. So you are entering, you are not expected to, you are not expected by the law to enter into this. But once you enter, you must make your decisions based on the legal framework available. If you now go outside the legal framework, you're not looking for trouble. So in that manner, it is now restricting your social behavior. It is now controlling your social behavior within that legal framework. Because it would now be dangerous if you say, okay, you can do anything you want to do without putting a barrier. Social control. Now we have the constitutive technique. When we talk about the constitutive technique, we are talking about it as an offshoot of the private arranging technique. Now remember I said that private arranging technique is when you are given the opportunity within a legal framework to do what you want to do within that legal framework. It is you that have the powers to do what you want to do, but it must not go outside that legal framework. Now, constitutive technique, when we want to talk about it, we're talking about it in the aspect of when you now come together also to open a company or to form a legal personality. Now, when we talk about constitutive technique, we are saying you are constituting another person, but not a natural person. You are trying to constitute an artificial person, but it must be within the framework that has been established. How do you form a company? Just like a private arranging technique. Remember I said it's an offshoot of the private arranging technique. But in constitutive technique, we are talking about forming a company, forming a business organization, forming a non-business organization. How do you come together, and in what legal framework will you choose whatever it is you want to do? Now, if you want to open a company, you have the private limited company, you have the public limited company, you have the unlimited company, we have partnerships. Yeah, we have company limited by guarantee, company limited by shares. You have all these options. These are the framework. Now, for you to choose, you must have to choose between them. So you have the powers to choose. And anytime you want to open a company, when you have opened a company, the company is a legal person, is a person on its own that can enter into a contract. You that owns the company, you are different from the company. That is the case of Solomon against Solomon. Go and read that case. Assignment. Read the case of Solomon against Solomon on legal personality. You are a person, you're a natural person. But once you open a company, it becomes an artificial person. So you that is the CEO, let's use me, Prof Limited. Me, I am Prof, and I have a company called Prof Limited. We are different. So my company cannot borrow money from your bank and you will come and hold me. No, you hold the company, not me. I am different from the company. Even though I am the major shareholder of the company, I am not the company. The company is not me. Even if it's your name they use, as far as it is a company, it has its own personality, it is its own person. That company can even enter into a contract with another person. Constitutive technique. It's an offshoot of private arranging technique. But when we are talking about business organization, we're talking about companies, we're talking about not only companies, we're also talking about incorporated trustees. Once the trustee is incorporated, then it has its own personality. It can sue and be sued in its own name. You read it, you will understand it better. Administrative regulatory. Now, most of the times you want to open a company or you want to start producing something, it must be subjected to some administrative regulations. NAFDAC is an example. How can you produce drugs or import drugs and it is not regulated? People will buy now. People, People will take drugs that are not healthy for them, and you would see that people will start buying. So how do you now control that social behavior? You have to regulate administratively what people are producing, what people are doing. Administrative regulatory. When the government is regulating what you are trying to do, okay, you want to open a school, you must have to get it registered, get the school to government for government to approve of you opening the school. And before they do that, probably they would have come to a site to take off your school activities, and they would see it and okay, say okay, it is fit for use. Plus other things like maybe your teachers and all that. The National University Commission goes from time to time to check universities, to check if they are still standard administrative regulatory. Because if they do not have these administrative regulatory people coming around to regulate them, it will be a problem, because what they do affects other people. So if what you are doing, what you are producing is affecting other people, it must be regulated, because if it is not regulated, it will be a big problem. So that is administrative regulatory. Fiscal technique. Most times people are being asked to stop a particular action, stop a particular behavior, but they don't hear. So most times they can use tax, heavy tax, and put on it. Not fine. I'm not talking about fine. We are talking about fine. We are talking about penal technique as a punishment. Fine as a punishment. We are saying tax. Let's say, for example, we want to get everybody to stop smoking cigarettes, probably because of how hazardous it is to the health. Instead of maybe criminalizing smoking cigarettes, the thing the government can do is to use the fiscal technique and put very high tax on cigarette importers. That even after taxing you, after you are being taxed, you will not even have profit again from your cigarette sales. What will not happen? People will stop selling cigarettes, and if people stop selling cigarettes, where will you see cigarette to buy? Then you now see that you have eradicated it using the fiscal technique. Taxes. Sorry, not tax. Now, conferral or social benefit technique. Now, most of the times, why do we see that these developed countries, most times, they are kind of, not as if they are actually, but it looks as though they are secure? Because most of their needs as citizens, I mean, social amenities and all that, have been met. So they have good schools, have work, they have good roads, they are living well, they are living fine. Unemployment rate is very low. Employment rate is very high in this developed country. So you now see that it would be easier to have a calm and orderly society once these social amenities are being provided for. And providing the social amenity is the conferral or social benefit technique. Provide these things for these people so that these people will be engaged, so that these people will be living fine. Because most of the times it is frustration that is making these people to go into all these crimes and all these behaviors that would be detrimental to other people. So when you now do the conferral or social benefit technique, you use it to make the society a better place for people to live. And when the society is a better place for people to live, then everybody will be orderly. Now, if you are out of school, if you go and engage in crime, and they will tell you, Shebi, there is work, Shebi, there is school to go to, free education, and you now coming out to steal, you do not have any excuse. Because now, you can catch somebody that is stealing and you say, yeah, because of hunger. That's an excuse. That's a very candid excuse, candid and honest excuse. Why are you not in school? I don't have money to pay for school fees. That is a very good excuse. So those ones that are not in school, they want to go and do other things. Maybe they say, idle mind is the devil's workshop. When they are idle, they will have to go outside to go and look for what to do, and they will probably follow bad friends and go and do bad things. But if there is school, if there is work that pay good wage, then you do not have excuse to be a criminal. So if you do that, if you provide these things, you are trying to control the social behavior of people. Because if they are at work, they are at work. Once after work, they must be tired, they will go and sleep. Instead of using that time to go and thief, they will go and sleep. The night before morning, they have woken up. go to work and go and stay. They are controlling their social behavior. The society will become a better place. That is conferral of social benefit technique. So remember, our assignment is for you to go and read Solomon against Solomon and note the meaning of legal personality. The company is an artificial person that can sue and be sued and can enter into contracts. Now, I will stop here for today. The video is very long now. Take care of yourself.